Justice Gorsuch's good questions earlier about Boyle and the interaction of Boyle with other branches of preemption. I think this is very important analytically that we have this straight, so I want to make sure we have it straight, which is, I think you're saying, put aside Boyle. We're not inventing another branch of preemption law. We are applying the longstanding, uniquely federal interest branch, which naturally would encompass at its core war making in combat, in a foreign country, in a war zone, right? So that's not a new branch.
That's not new.
But it also means you don't need Boyle. Like Judge Silberman said, even in the absence of Boyle, there's preemption in this kind of circumstance, and yes. That's your point. Put aside Boyle. Sweep, it's gone. You still win under this other branch of preemption law, is your argument?
Yes, our argument at its highest level is that the claims are preempted because they conflict with the Constitution. The Constitution not only vests the war powers in the federal government, but importantly, Article 1, Section 10, Clause 3 expressly withdraws the power from the states to engage in war. And these state tort claims, by imposing common law duties of reasonable care onto the battlefield, would interfere with the federal government's exercise of its powers. You can get there through Boyle. That's one line of cases to get there. You can get there through Garamendi, Crosby, Zhernig. Those cases recognize simply you can weigh the way that a state law or state law cause of action would interfere with the federal government's exercise of its powers. And if that's enough of a conflict, there can be preemption. As Your Honor pointed out, footnote 11 of Garamendi said, if we're dealing with an interest where the states don't have a historical role in regulating, maybe we should treat this more as field preemption. That's the circumstance we're dealing with here.
Two quick follow-ups. Congress could provide for state law, tort law to apply. So when we say the Constitution preempts, that gives it to Congress and the executive, but they could enact laws allowing this, correct?
Correct.
Okay. And then secondly, on Justice Barrett's question about what would the federal rule then be, I think your answer is, well, that's defined, but correct me if I'm wrong, defined by the scope of preemption, and the scope of preemption, you think, is if we're talking about a war zone, combat activities in a war zone, that is at the core of a uniquely federal interest.
Correct. The scope of the rule, the common law rule the court would adopt, is like it did in Boyle, is a rule for determining where there would be preemption and what areas would be left to federal common law and what would fall outside of there when state law claims would be allowed to proceed.